Is it possible to obtain a patent for something that's already been done, but not patented yet? And unfortunately, no. Unfortunately, no. The problem there is that to get a US patent, it has to be novel. It has to be first of its kind, and it's got to be yours. So if someone else came up with it and brought it to market, produced it, showed it to you, you're not the inventor. Just because you discovered it or found it or first one to see it, in your family or group or community, that doesn't mean you came up with it. So in order to file an invention, you have to be the inventor. And then secondly, it can't have been in the public before, right? So by the time you file it, the examiners will be looking at anything that's existing before that date of filing. And that can be patents. It can be non-patent literature as well. So really anything that's available to someone in the industry, in that field of invention. What would someone that's working on products, working on solutions in that field, what would they have at their fingertips? What kind of knowledge would they have? And so that's the standard that the examiners are going to look at. And so unfortunately, no, you're not able to obtain a patent for something that someone else already did, even if they decided not to get a patent on it. So hope that helps clarify that question. It's a good one. How do you protect your idea without a patent? What happens if you don't patent your idea? The truth is you do not need to have a patent to have a successful product. And you don't have to have it, right? If you move out to the market and you try to be a first mover to test it out, see how things go, or just forego the whole process of investing in a patent, that's okay. You just run the risk of having competitors see what you're doing and enter the market without any barrier, right? Of course, there may be some initial technology barriers to actually getting hold of materials, and they'll be second or third or fourth in line to get to your customer base. You're going to lose out on the ability to prevent anyone else from making, using, or selling that product. And so you'll have to expect a bit more competition. The other perhaps downside is if you decide not to sell right away, to a certain segment, of the world or a different part of the country, you're really allowing your customers to be taken away. So it's definitely, advantageous to seek a patent if you can, if it's something that you think is worthwhile. The only times where it's really not worthwhile to get a patent is if there's, what you're doing is not readily reverse engineerable. And so there's certain areas of technology, certainly within software or things that are harder to kind of follow, methods or processes, specifically in manufacturing. I'll use this example a lot from when I was at Boeing, where they kept trade secrets, right? Trade secrets, manufacturing secrets for how they made, for example, the carbon fiber, and exactly the dimensions and the orientation of the different layers of fibers, how long they would heat it, and how long it would actually take to cure, and the mill methods and the certain chemicals they would put on, adhesives put on to finalize that end product of the composite wing. Well, even if someone in the new airplane wings and knows the structure, bought an airplane from Boeing, hammered it apart and tried and looked at the materials, they still couldn't tell what steps were followed to actually make that material and to get it at that strength and value. So there's certain aspects where you may want to actually keep something as a trade secret. If once it's sold, it's really not going to be reverse engineerable. There's a second part, actually the first part of this question about how do you protect an idea without a patent, and that's through trade secrets. The other idea might be to license it. Okay, so you can transfer what's called know-how and transfer some structure, right? Some contractual level of information, even though it's not actually patented. And this does happen sometimes with companies where they're coming out of universities and there may be one or two more patent filings, but there's some additional knowledge, right? The how you actually build it. I was explaining an example about Boeing. Some of that information that can be valuable can be transferred and monetized without actually having gotten a patent on it. So this question is, can you explain the meaning of trademark in the context of a company's name? What is the purpose of registering a trademark? I do think it's important for a lot of people to understand there is a difference between the actual company name, right, that you file with the Secretary of State versus what you'll be filing with the Trademark Office. Usually, in a lot of cases, the name of the company matches the, how you're going to market, right? Our law firm is Bold Patents, but the actual law firm name is Bold IP, PLLC, right? So we actually have gone after Bold Patents as a specific trademark with the USPTO and the Trademark Office. And so it's all about how do your customers perceive you, right? How is your goodwill being brought up? And your company name, right, behind the scenes is Alphabet, right, Corp, but they're going to market as Google. Okay, so they're likely going to first try to go after Google because that's the most important. That's where the customers interact, and that's what will be really foundational for deciding whether that is distinctive, above and beyond, or different from other competitors in the market. So that's something key to understand, that you don't really want to try to protect the company name unless you're going to market under that name. Or the purpose of registering a trademark is so that federally, right, if you're conducting business online in any way, you're conducting interstate business, interstate commerce, and you want to get protections to prevent consumer confusion. That's the overall goal under the Lanham Act, is to help consumers make sure there's not going to be the same name, right? So when you go to buy a bar of soap and it says Ivory, you know what that soap is. You know the level of quality of that soap, where it came from, the source of the goods, and that someone that's come up with a new bar of soap can't even come close to that word Ivory without infringing on Ivory soap. So there's sort of that understanding the value for the customer before they make a purchase decision as they get to know the brand. I've heard that in some cases, changing the length and thread of a screw and moving its position in the construction of a patented machine may make it immune to patent infringement. So if material alterations constitute an infringement, how is it that changing a screw, which seems so much less of a change to the original design, not be considered an infringement? Is there simple guidance to follow if an inventor's intellectual property has been violated or not? Or did I just hear a bunch of nonsense? I'm not asking for legal advice, but just in general. Yeah, good. So I think the question is, to what degree can I build something, make something, use something, and avoid infringement? And I'm not sure if I followed the screw example, but what I can say is that when you're making a product and you're worried about whether you're infringing on the patent claims, you have to go read each claim. And the claims of a patent are at the very end of it. They kind of make you read through all the description, all the drawings. That's not what the inventor, what the applicant, the owner of the patent actually owns. They own the claims, the written numbered set of claims at the very bottom of the patent. And so start with the independent claims, usually independent claim 1, and you've got to break it down into the little elements. And we'll look at an example from the Shark Tank pitch later today, where it'll have structural elements, right? It'll say, a machine with a bottom case, having a plurality of penetrations for securement attachment, wherein the attachment has a positional ornamentation for rotation around its axis, right? And they'll have maybe 4 or 5 other elements where it'll say, and then the dependent claim might be the said attachment mechanisms can include or consist of screws. Okay, and so that's one of the potential embodiments, is to attach this machine to the top with screws. I think the fact that you're using any type of attachment means screws or not, or adhesive or not, probably likely going to be infringing. The way to avoid infringement would be to not have in one of those elements in the independent claim. And I know I'm talking a lot here, but that concept would be, if you're able to come up with that same motor without having any attachment means, now you're not infringing, right? Or construct it so that it doesn't rotate around its axis at all. It's fixed. That's not infringing. These are relatively technical, and I think before you put a ton of money or effort into buying or manufacturing or developing a product, you want to get with an attorney, patent attorney, and work on what this is, the FTO, freedom to operate, and say, hey, I'm going to market with this product. We're not necessarily looking to get a patent ourselves, but I'm worried about this patent. Am I infringing it? And get an opinion from an attorney that says, you know what, no, the elements here, you're not on the merits infringing, and if you were sued by this company, we stand behind the fact that you are not infringing. And so it's something you'll want to have, especially if you want to go after higher investors. They'll be assured by the fact that you've got an attorney review it, before you've gone to market, taking that big risk of litigation.